What is the duty of reasonable care for an LLC member? My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota and New York City. Today, let's take a look at one of the duties that you have if you're the member of an LLC. Admittedly, the duties you have as a member of the LLC are probably one of the last things you're thinking of when you create that business. We're usually excited, we're working with friends, or we're creating our own business for the first time. We can't wait to get our business formed with the state. We've got our articles of organization, and hopefully we're remembering to do our operating agreement. And so we've created our operating agreement for the LLC, and we're ready to go, and we're ready to get into business. But we don't often think about, what are my duties to the LLC? So if it's a single member LLC, this is usually really back of your mind. It's not something you're concerned about because there's not always going to be somebody there to hold you accountable if you violate one of your duties to the LLC. However, if you have other members of the LLC, other people to whom you owe a duty because you're all members of the LLC, it's important that you understand what these various duties are. Today we're going to look at the duty of reasonable care. So this is one of these duties that's in law that you have as a fiduciary, as a member, as one of the owners of the LLC that you have to keep towards the LLC. So this duty has three main things you probably should know about. Number one, you need to act in good faith. So you're making decisions, you're representing the company, you're working in the business, you need to act in good faith. You have to be honest, you have to act with integrity, you have to not be using the LLC as a way to launder money or hide things or get involved in nefarious schemes. So we want to be acting above board and acting in good faith as a member of the LLC. Number two, we want to exercise reasonable care. Now this is one of those legal terms, and this is where lawyers come in, and if you have a lawsuit or there's a fight over what that duty looks like, reasonable care is probably spelled out in a whole line of cases in your local state's law books. So with that exercising reasonable care, this is usually going to be making informed and making prudent decisions. So going back to acting in good faith, we're making informed decisions, they're going to be prudent, we're going to make sure that we're acting in the best interests of the LLC. And number three, you need to be responsible with your decision making. So you're making informed and prudent decisions, and we need to be responsible. If we're making a major acquisition, we're doing big financial decisions, you need to be responsible. It's kind of interesting that they have to spell out all these different parts of the duty of reasonable care because they should be things that are pretty standard. I mean, you're starting your LLC, whether with your friends or with business partners, you assume that they're going to act in a way that's reasonable towards you, and you're probably assuming that you'll do the best for the company as well when you set it up. Very few people join an LLC with the purpose of tanking the LLC or destroying it. Sounds like a great premise for a TV show or a reality show. Try to find which LLC member is here to try to destroy the LLC. But in reality, LLC members are normally acting in the best interest of the LLC, and so the duty of reasonable care isn't something they're worried about violating. People will ask me when we're discussing the duty of reasonable care, do you have like a checklist or something that I know I should be doing as an LLC member? What do I have to do to fulfill that duty of reasonable care? So let me give you 5 quick things that you can think of that keep in the back of your mind for how you can make sure you're fulfilling this duty. Number 1, stay informed. Know about the operations, the finances, and important decisions of your company. Make sure you're involved and you're talking to people. Even if you're a minority owner in the LLC, maybe you only have 10%, you still want to make sure that you understand what's going on because you are a 10% owner of that LLC. You're called a member, not an owner, but you need to make sure that you understand that you're fulfilling your duty and paying attention to it. Number 2, document your actions. So maintain records. So if the members are meeting and you're having discussions about whether you should acquire that other company or not, and you have one member who's just kind of off in left field and wants nothing to do with it, but everyone else is looking at the books and saying this is a good investment for us, you want to make sure you've got a record of the actions and record of those discussions so that your ability to fulfill your duty of reasonable care doesn't get questioned. People can look at the records and say, oh, no, they already discussed this as part of the acquisition. Number 3, seek expert advice. So this is an interesting role that I've played over the years for a variety of members of LLCs. And that is, in addition to having a corporate attorney who represents just the LLC, members can also have their own personal attorney. So I've been personal attorney to a variety of owners of businesses in these kind of situations where they say, wait a second, I'd like to have my own independent attorney work with me and review this action or review this decision and decide whether I think it's in the best interest of the company. Maybe I'm concerned from a legal standpoint about an antitrust violation of this decision or some other legal issue that may arise. So you can absolutely have your own personal attorney. And so you want to work with experts. If it's not an attorney, maybe it's an accountant. You say, wait a second, before we enter into this big transaction, I want to understand what the effect is going to be on my taxes. So I want to be fully informed. Number 4, avoid conflicts of interest. It seems like it should be pretty simple, that nobody should have conflicts of interest, but when they arise, they can become a big problem. So let's say you have another separate company and you're now going to start intermingling the finances between the two, or maybe one LLC is giving a huge discount to the other LLC. It might seem like a good idea on paper, but there may be a conflict of interest. And going back to tip number 3, work with experts to make sure that if you're engaging in something like that, that you're not actually violating this duty, that there isn't a conflict of interest. And number 5, regularly review the LLC's affairs. Look at the financial statements, your contracts, your other important documents. Make sure, just like number 1, you're staying informed. You're reviewing the documents. You understand what's happening with the LLC. Because although you're limiting your liability, you still have this duty of reasonable care to the company, to the LLC, and to the other LLC members that we want to make sure we're fulfilling. If you have more questions about your role as a member of an LLC, or if you have other questions about setting up an LLC, you can head over to my website, andrewmayers.com. There's a red button on the front page that says Legal Strategy Session. You can click that and you'll be taken to my personal calendar. We can set up a 15 or 20 minute session to talk on the phone and go through your questions about your duties as a member of an LLC. If you like this video, you can hit the like or thumbs up button below. You can subscribe on YouTube for future videos. And remember, if you're a member of an LLC, you need to make sure you understand these duties and how they affect you and your relationship with the LLC.